Good morning and welcome to the series of legal aspects of medical practice. Our today's topic is confidentiality in medical practice. So what is confidentiality in medical practice? My dear friends, when a patient approaches to a doctor, that patient has to reveal all the information regarding his or her illness to the doctor. And without revealing all the information to the doctor, that patient cannot expect the best possible treatment and diagnosis from the doctor. So it is very essential for the patient to disclose all the information regarding his or her illness to the doctor, and doctor cannot arrive to the proper diagnosis and treatment without a disclosure of the information about his or her illness by the patient. So it is the disclosure of the information which is required for proper diagnosis and treatment of that patient, which is required to be disclosed by the patient to the doctor. So sometimes this information which is disclosed by the patient to the doctor about his or her illness is private or personal in nature. So naturally patient does not want to disclose it to anyone else. Sometimes patient prefers to disclose only to the doctor, and sometimes not even to the family members or friends or any other person. Because there is fear in the mind of the patient that if I will disclose this information to anyone else, there may be social stigmatization, or there may be humiliation, or even the family members may cause some humiliation or stigmatization, or sometimes patient has the fear of losing the job or some stigmatization or humiliation at office, etc. So it is the duty of the doctor to build the confidence in the patient's mind that the information revealed by him or her regarding his or her illness will not be revealed to anyone else, and this is the confidence that is only going to build a rapport between the patient and the doctor, and only because of which, or only because of this confidence, patient is going to reveal all the information to the doctor. And unless and until this information or full information is disclosed by the patient to the doctor, doctor cannot arrive to the proper diagnosis and treatment, or even the patient cannot expect from the doctor to do best possible diagnosis and treatment. So of course here there is a duty of the doctor not to disclose the information of the patient to anyone else without the consent of the patient. In fact, this is the duty of the doctor not to cause a breach of duty or breach of duty of the confidentiality of the patient's information. And it is the duty of the doctor to preserve and protect and respect the information which is disclosed by the patient to you on the basis of fiduciary relationship. So it is not only the ethical duty but also the legal duty of the doctor, and if it is breach or some breach of duty is caused by the doctor, or doctor discloses the information of the patient without the patient's consent, doctor may have to face some legal consequences. Now, though it is true that doctor should not disclose the information of the patient to anyone else without the consent of the patient, but there are certain exceptions in which doctor can disclose the information of the patient. What are those exceptions? First is by the consent of the patient. When the patient himself or herself gives the consent to the doctor that he or she that doctor can disclose the information of the patient. For example, when you are getting as a doctor very good results in some difficult cases, and you want to publish it for other patients' benefit, or so that all other patients of the similar nature will be benefited by it. So in that case, you have to take the consent of the patient, or if you want to disclose the information for the medical research purpose, so in that case you have to take the consent of the patient. And if the patient himself or herself gives the consent to the doctor, then there is no harm in disclosing the information of the patient. Then second thing is that in best interest of the patient. Sometimes we come across a situation when patient himself or herself is not in a position, or patient having not capacity to take the decision about his or her own health or illness or the further course of treatment, because patient is critically ill. So in that case, it is necessary for the doctor to disclose the information of the patient to the nearest relative of the patient, so that those relatives can take the decision about the patient's further course of treatment or patient's health, or about the patient's illness. So in the best interest of the patient, it is necessary for the doctor to disclose the information to the relative of the patient without consent of the patient, because patient is not in a position to give the consent. Second or third thing, that is when the patient is minor, or patient is of unsound mind, therefore there is no capacity no mental capacity of the patient to take the decision about his or her illness. So in that case, doctor can reveal the information of the patient to the parents, guardian, or to the legal guardian of the patient. Then the next important, that is the communicable diseases. When patient having some communicable disease or some notified disease that we experienced in case of COVID-19. So in that case, it is the duty of the doctor to disclose the information to the concerned health authority of your area, so that it will help that authority to take some preventive action or curative action. The next that is most important is when you have the reasonable suspicion that patient has committed some kind of offence himself. So in that case, you have to inform to the nearest police station. So again, under POCSO Act, that is when you have the reasonable suspicion that some kind of offence or some kind of sexual offence has been committed against that child. So it is your duty to inform as early as possible to the nearest juvenile police station, or if there is no juvenile police station available in your area, to the local police station. So if you will fail in case of sexual abuse, or when you are having suspicion that some kind of sexual offence has been committed against that child, so if you fail to inform to the nearest police station, then you may have to face legal consequences. Then next is when there is serious and identifiable risk to a particular person or to the community at large. So in that case, you can disclose the information of the patient even without the consent of the patient. For example, when the patient having HIV, and if you think that patient is not going to disclose this information to the spouse, so in the best interest of the spouse who will get affected, of course. So in that case, you can disclose this information to the spouse in the best interest of that spouse, or in the best interest of the childs who are going to be born. So I would like to highlight one very important or very famous case, that one Dr. X was working in a hospital, and during the course of his employment he became HIV positive, and this test result came positive while there was a routine checkup of all the staff of the hospital. So this information was disclosed by the hospital to the girl or to the family of the girl with whom this doctor was going to be married very soon. So doctor sued the hospital that his private information was disclosed and there is a breach of confidentiality, and he has the right of confidentiality of information. So that hospital should be punished and should be ordered to give compensation to him. But in this case, court said that though there was a breach of duty or of the confidentiality by the hospital, but what the hospital did, that was in the best interest of that girl who was going to be married, and if hospital would not have disclosed that information, then see the prospective bride was supposed to be infected with the HIV, or even the children who were supposed to be born after the marriage of that couple were supposed to be infected by the HIV. So in that case, right to confidentiality of information is less important than the right to life, which is more important here. And there was some identifiable risk to that girl also and to the children who were supposed to be born after the marriage. So here there is identifiable risk to the specific person or to the community at large if the information is not disclosed by the doctor. So in that case, you can disclose the information of the patient when there is serious and identifiable risk to the specific person or to the community. Then sometime for the official purpose, it is required to be disclosed. For example, when a patient requests you to issue the medical certificate to be submitted in the office, so in that case, you have to write the diagnosis of the patient. That means we are disclosing the information of the patient. So it is necessary because it is in the best interest of the patient. Sometimes we are referring the patient for the further treatment or for the investigation or diagnosis. So in that case, of course, you have to disclose, or you have to send the information of the patient or send the information of the treatment given and every relevant information of the patient to the doctor to whom you are referring the patient for the diagnosis or further treatment. So in that case, there is no breach of duty because it is in the best interest of the patient. Then in case of post-mortem examination, when a doctor is doing post-mortem examination, of course the information about that patient is to be disclosed to the investigating officer, because postmortem is basically done to arrive to the conclusion about the cause of death. So it is an aid to the investigation procedure. So of course we have to inform the investigating officer about the cause of death. So here you doctor who is doing post-mortem examination can reveal the information of the patient to the investigating officer. Then sometimes the disclosure of the information is required by the law. For example, when the court asks about the information or about the treatment of a particular patient, or sometimes police are requesting to submit the information of the treatment of a particular patient, about the injury of the patient to whom you have treated. So in that case, it is your duty to submit the information to the police or to the court of law, because as per the law, as a citizen of India, it is our duty to aid in the process of justice or process of law. Then sometimes this disclosure of information is requested by some insurance company. So if you will not disclose this information to the insurance company, of course that patient is not going to be benefited by this his or her health insurance policy. So in that case, you can disclose the information of the patient to the concerned health insurance company in the best interest of the patient. Now there are certain guidelines regarding the disclosure of the information of the patient. So first is about the guidelines given by the Medical Council of India. So as per the Medical Council of India Regulation 2002, when a request is made by the patient himself or by the dependents of the patient or by the legal representative of the patient about the medical record of the patient, so in that case you have to acknowledge the same and you have to issue the information or patient's medical record within 72 hours. And of course here you can take the charges for administrative purpose, for example Xerox copy and all this, but you have to issue the medical record within 72 hours. So here it is very clear that you cannot refuse to give the medical record of the patient for the reason of confidentiality. Then second thing is that in case of publishing, sometimes we are getting the very good result in some patient who is very difficult to cure. So of course we want to publish this information so that all other patients will be also benefited and also we will be benefited as a doctor or hospital. So in that case, it is very essential that you should not disclose the information of the patient without the consent of the patient. If the identity of the patient is going to be revealed, if the identity of the patient is not going to be revealed, then there is no necessity to take the consent of the patient. So how this identity is going to be disclosed? If you are disclosing the name of the patient, identity is going to be disclosed. If you are revealing the photo or you are publishing the photo of the patient, identity is going to be disclosed. Or even when you are not disclosing the name of the patient, you are not publishing the photo of the patient, but you are disclosing the time or date on which patient you have treated the patient and the location from which the patient came, then also it can be said that there is disclosure of the information of the patient or identity of the patient is going to be revealed, and patient can sue you in the court of law and demand compensation from you for breach of confidentiality. So in that case, you should not publish the information of the patient if patient has not given you written consent. So without the written consent, you should not publish any information of the patient when the identity is going to be revealed by any means, not only by name or photo, but by any other means. This is very important, especially when we are getting some very good results and we are publishing the information, especially nowadays on the WhatsApp or through the video. So in that case, we have to take this precaution. Otherwise, patient may file a complaint against you that his my information was revealed or my identity was revealed without my consent, and patient can demand lakhs of rupees of compensation from you. Then next is for the medical research purpose. The same rules are applicable when you are publishing the information of the patient for medical research purpose. Here you have to take the consent of the patient if the patient's identity is going to be revealed, or if the patient is already dead, then you have to take the consent of the legal heirs of the patient or the dependents of the patient. And if you are disclosing the information without the consent, then the patient himself or the dependents of the patient can sue you in the court of law. Again, when you are disclosing the information for the medical research purpose, in that case you have to follow the guidelines given by the concerned authorities like ICMR. And also you have to take the precaution that such disclosure of information for the medical research purpose should not cause any kind of inconvenience, discomfort, humiliation or social stigmatization either to the patient or to the family members or to the dependents or any other person who is related to that patient of which you are going to disclose the information. Then next comes about the sex determination test. As you already know, it is strictly prohibited that when the fetus is in mother's womb, no information should be disclosed by the doctor that a particular fetus is of a particular sex. It is strictly prohibited, as you know, under PCPNDT Act, also under MTP Act 1971, and also under the Section 7, subsection 6 of MCI regulation. So you should take the precaution that in no way sex determination or the information regarding the sex of the fetus should be revealed to anyone else by any manner. The next very interesting point, that is right to information. Very often the questions are asked that whether the information should be revealed or disclosed under Right to Information Act. Here I would like to discuss in detail. So first thing is that by whom the information has been asked. If it has been asked by the patient himself or by the dependents of the patient, then, or the legal representative of the patient, then I think it is just wastage of time, because as we have already discussed under MCI regulation 2002, when patient himself or the dependent or the legal heirs submits the application for the medical records, doctor or the hospital has to issue that medical record within 72 hours. And here under RTI Act 2005, that patient will get the information within 30 days. So of course it is not beneficial for that patient. So of course whenever the patient is asking information under RTI Act of his own or of or when the dependents are asking the information, so in that case I want to say that it is not necessary for them to ask under simple application is very beneficial than RTI Act. Then if this information has been asked by some person other than the patient or the dependent or relative or the legal representative of the patient, then here the point comes whether to disclose the information or not. So only thing is that you can or you have to disclose the information only if there is larger public interest. If there is no public interest or it is not in public interest, then there is no reason to disclose the information of the patient, because the information of the patient is confidential in nature, because though the medical record is owned by the hospital or the doctor, the information contained in that is owned by the patient. So it is confidential in nature, so you should not disclose it to anyone else under RTI Act unless there is some larger public interest, and which is more important than the confidentiality of the information of the patient. Only if there is a larger public interest, then it is more important than the confidentiality of the patient's information. So only in that case you have to give the information of the patient under RTI Act. Then what comes next, that is the privileged communication. So what is privileged communication? That means we have the right to withhold certain information and not to disclose anyone else, or we cannot be compelled to disclose the information. But as far as the doctors are concerned, this is not absolute right, though it has been given under section 122 to 129 of Indian Evidence Act. But as far as the doctors are concerned, it is not absolute right. That means we cannot always withhold the information of the patient. Whenever necessary, as we have already discussed in this video, so whenever necessary, you have to disclose the information of the patient in the conditions or circumstances as we have already just now discussed. Then the last but not least important question that comes: what are the remedies available to the patient if the doctor discloses his or her information without the consent of the patient? Or what kind of action can be taken against doctor if doctor discloses the information of the patient without the consent? So first and most important is a complaint. Patient can make a complaint to the respective council, that may be Medical Council of India, now it is called as National Medical Council, or the Homeopathy Council or of Indian Medicine, as according, or it depends on of which pathy the doctor is. So patient can make a complaint to the respective council, and council may take appropriate action against the doctor. The registration certificate of that doctor can be suspended for a temporary period, or it can be cancelled permanently, depending on the nature of the breach of duty caused by the doctor. Then second thing is that if the patient's information has not been yet revealed to anyone else, but there is a reasonable suspicion in the patient's mind that his information is going to be revealed by the doctor to anyone else, and if that will be revealed, then it may cause some harm or injury or some kind of inconvenience, humiliation or discomfort or social stigmatization to him. So in that case, patient can approach to the court under Specific Relief Act section 38 and 39 and request the court to issue preventive order, that is called as injunction, prevent the doctor or prohibit the doctor from disclosure of the information, so that doctor will not disclose his or her information, and if the doctor will not obey the court's order, then doctor may be punished. Last but not least important is that suit for damages. If the patient's information has been already revealed by the doctor, then there is no use of preventive injunction under Specific Relief Act. Then patient can sue the doctor for the damages which is caused to the patient due to the disclosure of information by the doctor without the consent of the patient. So it depends on the what kind of harm or injury has caused to the patient by disclosure of the information by the doctor to someone else without the consent. So if it has caused defamation, then patient may file a suit for defamation or accordingly, or if it has caused some monetary loss to the patient or damages to the patient, then patient may file a complaint against doctor accordingly. So doctor can be sued by the patient for the damages which has been caused by the doctor by revealing the information without the consent of the patient. So these are some action which can be taken against doctor by the patient, or the remedies which are available to the patient against the doctor if the patient's information has been revealed without the consent and without the exceptions which we have just discussed. So this was in short about the confidentiality in medical practice. I hope all of you will be benefited, and if you like this, please subscribe and share and press the bell icon below this video. Thank you.